So the lawyer for Mickey Stines has filed a motion to dismiss, which on its face sounds crazy and absurd because Mickey Stines was the guy that had shot and killed the judge, right? The sheriff of Letcher County had shot and killed the judge of Letcher County, and it seemed like it was done in cold blood, and we don't really have a motive, what the actual reason was. So a motion to dismiss the indictment, a motion to dismiss the indictment, but there was a preliminary hearing, so that doesn't even make any sense because probable cause has been established. Is there probable cause that perhaps a crime may have been committed? There's a dead body, and a lot of times when there's a dead body, I feel like that's probable cause. There probably a crime has occurred here, and that goes, that's a sword that cuts both ways. There was an unnamed SWAT deputy that had shot and killed a person, but we didn't charge him at all. Why? Well, was there probable cause or not? It doesn't matter if there's probable cause. He's on our team, and since he's on our team, we're going to let, some people go. It's ridiculous how unfair the so-called law is. It's almost like there is no law. It's just all politics, and you could just kind of cherry pick any and every law that even Neil Gorsuch had said that. There's so many damn laws on the book that somebody can, arrest another person for, an infinite number of infractions. A lot of petty, tiny little things that nobody even knows about. So I want to go through this motion a little bit here because I wonder if the court system, which is run by judges, but it's also run by, prosecutors and clerks, and we just got a new Supreme Court justice, right? You got a new Supreme Court chief, and so with all these changes and influxes, and is anybody on the same page? Is anybody really paying any attention to any of this? So Kentucky v. Stines, right? This is the 47th Judicial Circuit, Letcher Circuit Court, Criminal Action 24 CR 00204. Okay. So this is the motion to dismiss the indictment. Let's go through this and see what the lawyer is talking about. This is impressive that, Jeremy Bartley is actually taking this case. And so therefore he'll get, a bunch of publicity, and maybe that's the reason why he's doing it. Maybe he knows the guy, I can't presume that he spent a bunch of money on this lawyer. But Sean Mickey Stines, comes now the defendant, right? You got to have that legalese that's embedded in all this, by and through the undersigned counsel, pursuant to the 5th and 14th Amendments and Section 11 of the Kentucky Constitution and Commonwealth v. Baker. Of course, you can never forget Commonwealth v. Baker. I mean, that's what Kentuckians live by. Kentuckians live by Commonwealth v. Baker. Let's actually take a look at Section 11 of the Constitution. Section 11 is the rights of the accused in criminal prosecution and the change of venue. And does it mention anything about the grand jury? The grand jury section is Section 12. So, I don't know. I feel like he might have missed that. But Section 11 seems very similar to the 6th Amendment. Commonwealth v. Baker. It's got a footnote. Is the footnote here? No, it just says that it's an appeals court. Kentucky Appeals Court 2000. Hereby respectfully moves this court to dismiss the indictment in this case. Specifically, defendant believes that dismissal is mandatory under RCR 5.16. So what is this RCR 5.16? Let's see if this Kentucky rules, right? Is this the RCR criminal rules of procedure? Is that what I'm hearing? Is that what I'm supposed to? Westlaw's got a little document here. Let's see if we can do this quick enough. RCR 5.16 transcript of testimony. There's 3 parts there. It says that the attorney for the Commonwealth shall cause all the testimony before a grand jury to be recorded. Failure to have a record made, if required by paragraph 1, shall be ground for dismissal of the indictment unless the Commonwealth can show good cause for the failure. Mechanical failure of the recording device shall constitute good cause. 3, the stenographer or operator of the recording device and any typist who transcribes this stenographer's notes or recording shall be sworn by the court not to disclose any testimony or the names of the witnesses. Okay, So there does seem to be a law. There does seem to be a law that specifically says, yeah, Mickey Stein gets to walk. He gets to walk. They did an indictment. They had a grand jury. They forgot to record the damn thing. And, if that's true, if that allegation that they didn't record some part of the proceeding, I want to say that there was a conversation before the witnesses. And so he was like, you didn't record that very beginning, that conversation. So the intentional failure of the Commonwealth to record proceedings in front of the Letcher County Grand Jury. Additionally, the grand jury was deprived of information known to the Commonwealth, sought in questions by grand jurors but not disclosed. So this is interesting. Lawyers try to find technicalities all the damn time to get their clients off the hook. Notably, Alec Baldwin, right? Alec Baldwin shot that woman in the face, and turns out that somebody put a bag of bullets on the prosecutor's desk, and she didn't include the bag of bullets in the prosecution's discovery report. And the bag of bullets, who knows if it has anything to do with anything, but that was enough of a reason to go ahead and throw that case out. Jury didn't even look at it. We were deprived of a jury trial when it came to that. Which is fucking ridiculous. It's fucking ridiculous. Basically, in America, if you're wealthy enough, you could just go straight out to Fifth Avenue, shoot a guy, and if you got $1 million in the bank, you'll find a lawyer, and he'll, take it to court, and then probably end up finding a technicality. So it's interesting with this case, will the judge see the lawyer's perspective, even though that this case was about the sheriff shooting and killing the judge? I feel like the judges aren't going to just, let this thing go. They're not just going to find some sort of technicality. Sure, you can, shoot and murder a Helena Hutchins. That's fine. You could shoot and murder a Helena Hutchins. What is she, a cinematographer in New Mexico? Who the hell is Helena Hutchins, right? You'll go ahead with the technicality, but then, to ignore that a judge had been shot and killed. Well, I don't know if a judge could do that because, even though the criminal justice, they're all kind of on the same team, the white-collar mafia, cops, prosecutors, clerks, judges. Well, this is a judge, right? Sheriff had shot a judge, so now you're going to see some infighting. So they're going to try to point out some facts. We're barking at something here. I'm going to presume it's not anything big. Probably the cows are walking around, and now we got another one barking. I'm going to carry on with this, and hopefully I'll drown out their barking. Cows are not an emergency. That's not an emergency, okay? To them it's an emergency. It's not an emergency to me. Oh no, the cows are by the house. Who gives a crap? And that kind of sucks too, because that's like the boy who cried wolf. They're afraid of the cows. And maybe they just hear some rustling outside. We've had some terrible inclement weather. So, I don't think that there's some crazy gunman on the loose. There's no genocidal, Israel running around here. Let's go on. Facts. On November 21st, 2024, Kentucky State Police Detective Clayton Stamper testified before the Letcher County Grand Jury seeking a murder indictment against Sean Mickey Stines. So this is just talking about Clayton Stamper had testified in front of it, okay? There was a prior meeting between the Commonwealth and the Letcher County Grand Jury regarding Mr. Stines that was not recorded. So they're saying that he was on the record, Clayton Stamper, but then they're saying that there was a conversation that happened right before that had happened that was not recorded. At the recorded meeting, grand jurors sought information as to the relation between the case sub judice. Oh man, they love that Latin too, right? Sub judice. When it comes to these judges, they sit up on high, and you got to really make them feel, good. And so just throw out a nice little Latin phrase. Sub judice is under judicial consideration and therefore prohibited from public discussion elsewhere. Oh, okay. I thought Latin was a dead language. Why is it so alive and living in all these damn briefings? But at the recorded meeting, grand jurors sought information as to the relation between the case, sub judice, and the companion federal civil case, but were deprived of the information. So they're just saying, what is the relation between, the criminal and the civil case? Testimony in response to questions asked by the grand jurors was frequently redirected to deprive the grand jury of its independent investigation. That's interesting. That's interesting. I don't know how, the beginning of the conversation wasn't recorded. So, I guess in the presence of the grand jury, he might have a point with that particular law. And then typically, if this wasn't about shooting a judge, if it was about Helena Hutchins, I would see that the judges would throw it out. But since it's about shooting a judge, I mean, we can't find a technicality for that. We got to actually take this one serious, right? You got to establish justice. That's the whole point. A lot of times it doesn't seem like, prosecutors and judges want to establish any sort of justice whatsoever. And this is, so disappointing to me because, here I'm thinking that America is consistent. We got these categorical imperatives. Nobody's allowed to rob, rape, murder, arson, steal, whatever. We have these big crimes that, nobody's allowed to do. And then we have these rights and freedoms that nobody's allowed to infringe upon. And then everybody's on the same page. If you can't even say that the U.S. Constitution and the Bill of Rights is American common law, do we even have an American common law? Why would we talk about old ancient English common law as if that, as if they're on the same page, as if there is any commonality between the old ancient English common law? The common law, old ancient English common law, just feels like it's some, corrupt lawyer trying to cherry pick and pull a monkey out of his butt. That's what the old ancient English common law seems to me. Well, according to the rule of King Henry VIII, King Henry VIII, the guy that killed two of his queens because he wanted to have sex with his mistress, was it Anne Boleyn? He got Anne Boleyn beheaded because he wanted to get with that, what was the next one in line? I forget her name, right? I mean, Seymour, Jane Seymour. Man, hey, judge, can you just convict her so I can have sex with Jane Seymour? But Anne Boleyn is your queen. She was my queen, but I can't get it up for her anymore, I just can't get it up for her anymore. And Jane Seymour, man, is she looking good. And then if that's the common law, also, I can go on about the common law. My God, the ordeals, old ancient English common law, you would have, there's the trial by battle. You would have also trial by cold water, trial by boiling water, trial by the cross, trial by the candle, trial by blood, the ordeal of blood, the ordeal of divination, the ordeal of, let's see, what else was the one? The one by blood is an interesting one. The ordeal by blood is this. You have a dead corpse. What you got to do is you got to get Mickey Stines to go to the corpse, and then for Mickey Stines to put his hand on the corpse. And if he puts, let's say he puts his finger on the corpse, say, on his face, that actually makes me think about Karen Reed as well. But if you put your finger on his face and blood starts coming out where you touched him, then that means the soul of the deceased is seeking revenge, therefore you're guilty. That's the ordeal by blood. And also if the corpse had moved. So you get the accused and you get them to touch the corpse, and if the corpse moves or blood spurts out, and Karen Reed, she pulls out a piece of glass out of John's nose and blood just squirts out all over the place. So the trial by ordeal, I mean, even there's, some logic behind the trial by battle, because God would side with the innocent, and the person who was innocent, wrongfully accused, would fight with more of a vengeance than, some lying piece of crap who's just alleging a bunch of false crap. But that's not smart or scientific or reasonable as well. I mean, you could just have, The Rock. The Rock could probably beat most people, right? UFC champions, they could probably beat most people. And that doesn't make them innocent. I mean, O.J. Simpson, he was a pretty strong person. So if he would have just, fought the Ronald Goldman's parents, and then he won the fight, then he gets to walk. That's stupid. That's stupid. The old ancient English common law did these ordeals. These ordeal by battle, ordeal by blood, ordeal by cold water, boiling water. And I'm getting a little off track, but the common law is horse shit, but people still talk about the old ancient English common law, just like they talk about the Latin law, and then we get away from the U.S. Constitution and the Bill of Rights, which it's like, that's the first part of law. When it comes to the hierarchy of laws, the U.S. Constitution and the Bill of Rights are supreme. That's the supreme law of the land. That's top. That's top shelf. That's top tier. You can't get no more natural law. Maybe you can appeal to God, God's law, divine law, eternal law. Hobbes, maybe? I don't know. Okay, so testimony in response to questions asked by the grand jurors. What's interesting about this is essentially the grand jury gets to do what they want to do. They can investigate who they want to investigate and then bring about any indictments. And it is supposed to be secret, which is interesting that we're recording grand jury testimonies when the whole thing is supposed to be secret. But you can find a damn law for anything, right? Well, hey. And then that's another thing with the grand jury. It's like these fucking lawyers would push for a grand jury so that way you could have 20 other possible infractions that you could, make a stink about. Here's another problem with lawyers. They can lie. They can lie. I just noticed it with, the civil case, the grand jury civil case that I'm working on, the 3 warning shots. But they lie and they just make up crap, and they don't have to prove they're not under oath, and they don't have to prove, what they're saying, what they're alleging. And so if you have just a conclusory allegation without any evidence, it's like, well, he's a lawyer, so we're going to take his, allegation, his bullshit, we're going to make his bullshit into a truth, and then we're going to turn the truth into, well, maybe it's the way it is, and maybe it's not. Which, just to mention something about, my case, the guy who made the arrest he wasn't even asked why he made the arrest. And here I have to say that I had served these fuckers, properly about fucking 5, 6, 17 fucking times. So I gotta say that I passed out the goddamn, legal documents properly and right, over and over and over again, whereas the person that can kidnap a person's body, he's not asked why he did it. What did you have probable cause? What was your reasoning? What was your rationale? Did you have good faith? Was it to function as your police? The functionality of your station. Was it good faith? Was it a reasonable standard? Was it a prudent standard? What was your standard for developing probable cause? He wasn't asked, and then there wasn't even a judicial determination on top of it. A lot of people aren't doing, there's many states that have grand jury in the Constitution, in their Constitution, but they get away with just having a preliminary hearing. But the preliminary hearing has to be just as meaty and robust as a grand jury indictment. So they're really getting away from a lot of shit, but it's just, it's just interesting to compare and contrast any of this stuff. Yeah, I'll carry on. But I think I need to do some creative writing just to, all you got to do is reverse the roles, right? Just reverse the roles. So I kidnap a person, and then nobody asks me, hey, why'd you kidnap that person? Did you do it right? Did you arrest them right? Did you go through the procedures? Did you do it by the book? Why'd you do that? I don't have to, if I had a badge, I don't have to explain myself 17 goddamn times because I produced the body. Now the damn court wants to rape the body. But if, the arresting officer was, doing a civil suit and it's like, well, did you pass the paper out? Did you pass it to him? Did you get the process server? Were they over 18? Did did they get the sign? Did they get it notarized? Did they sign it themselves? Yeah. Did they get it notarized? Okay. Did you videotape it? Oh, you didn't videotape it. So, okay, we don't really know what happened there. Maybe service was correct. Maybe it wasn't. Get the fuck out of here. The reason why that bothers me so much, if I'm the judge and you have, one of the parties who's using the authority of the federal or the state court to subpoena a witness, and the witness who's not in any trouble whatsoever, they just have to come into court and just, say what they saw and what they didn't see. If they want to, say, go to hell, then the court should be pissed off. Even if it's like, okay, well, his case, one of the parties' cases is going to be hurt. The truth is hurt. And then when the person who is rightfully subpoenaed by one of the parties say fuck you to the, one of the parties, they're saying fuck you to the state court and the federal court too. This is Phil Greene. They're saying fuck you to both courts. Ann Kelly defended Phil Greene because Ann Kelly defends criminals. It's more important for Ann Kelly to rubber stamp the kidnappings of a uniform, right? When that guy in Minnesota, he was wearing a uniform. And I guess they didn't comply, right? I mean, weren't they supposed to comply? He could have went in there and tried to make like a citizen's arrest instead of, being with the mask and saying it's a robbery and all this other stuff. Rule 5.16, transcript of testimony. The attorney, okay, so he actually had the rules right there, so I already kind of mentioned those rules. In the recorded session of the grand jury provided to defendant, a grand jury references a prior meeting with the Commonwealth. Defendant requested from the AG's office a copy of the prior meeting. The Commonwealth responded that the prior meeting was attended by the Commonwealth, but that it was only for the purpose of obtaining grand jury subpoenas for the case, and there was no testimony. First, the Commonwealth may seek subpoenas to a grand jury hearing without necessity of the grand jury intervening. Thus, it is curious what would necessitate the involvement of this independent body. Second, if a subpoena was sought from the grand jury, then information must be presented to the juries, while the Commonwealth must classify the information as something other than testimony, clearly related to the nature of the investigation, regardless of how it is labeled or whether it was sworn or unsworn. The information provided to the grand jury constitutes testimony and should be recorded. There was no mechanical failure. The Commonwealth chose to not record its meeting with the grand jury. The grand jury was denied information sought. The grand jury's functional independence from the judicial branch is evident both in the scope of its power to investigate criminal wrongdoing and in the manner in which that power is exercised. So this is footnote 3, U.S. v. Williams, 1992. And here's all that, I hate all that middle crap. I mean, we can't even agree that the U.S. Constitution is common law, but you're going to try to tell me that, well, according to the Kentucky v. Baker case of 1992, oh yeah, we're all on board with the Kentucky v. Baker case of 1992, let me fucking tell you. Anyways, however, the grand jury may choose to hear no more evidence than that which suffices to convince them that an indictment is warranted, may exclude the Commonwealth's attorney while they question witnesses themselves. The Commonwealth's attorney may not be present while the grand jury is deliberating or voting an indictment. Though the Commonwealth's attorney is required to draft indictments upon request of the grand jury, the Commonwealth's attorney does not sign the indictment, and the indictments are returned not to the Commonwealth's attorney but to the court. I thought the prosecutor is supposed to be there, and then are they talking about the Commonwealth's attorney who's like over the county prosecutor? The county prosecutor is supposed to be there, and they're just making it seem like the grand jury is supposed to do all this on their own. Nothing in our Constitution, statutes, or rules classifies the grand jury as an arm of the Commonwealth's attorney. The grand jury is an investigative body acting independently of either prosecuting attorney or judge. The hallmark of the grand jury is its independence from outside influence. This is all really good stuff of the Democratic Party of Kentucky versus Graham, 1998, U.S. v. Dionisio, 1973. So this is all interesting. Let's see. The grand jury is an investigative body acting independently of either prosecuting attorney or judge. The hallmark of the grand jury is its independence from outside influence. It serves the invaluable function in our society of standing between the accuser and the accused, whether the latter be an individual, minority group, or other, to determine whether a charge is founded upon reason or was dictated by intimidating power or by malice and personal ill will. An indictment returned by a legally constituted and unbiased grand jury, if valid on its face, is enough to call for trial of the charge on the merits. However, dismissal of an indictment by a trial court is appropriate if it is established that a violation substantially influenced the grand jury's decision to indict, or if there is grave doubt the decision to indict was free from substantial influence of such violations. A court may dismiss an indictment where a prosecutor knowingly or intentionally presents misleading testimony to the grand jury that results in actual prejudice to the defendant. That's Commonwealth v. Baker, according to the appeals court. So not even a Supreme Court decision, right? Well, the 2000 appeals court of Commonwealth v. Baker, and then Commonwealth. You're talking about the Commonwealth of Kentucky. So why would we call it the Commonwealth and not Kentucky? In Commonwealth v. Baker, a detective testified at a grand jury proceeding that the defendant struck her children with an aluminum baseball bat, while in reality the allegation was a stick that was used for the same purposes. Oh my fucking God. Talk about splitting hairs. She didn't attack them with the baseball bat. You know, you need to dismiss the case. Well, it was an iron rod. It was a large stick. Okay, well, you know, aluminum baseball bat, large stick. Tomato, let's just call the whole thing off. She can walk. Get the hell out of here. She struck her children with a large stick. After holding an evidentiary hearing, the trial court dismissed the indictment with prejudice. Hey, you said it was a baseball bat. It turned out to be a large stick. She's allowed to do that. You're allowed to beat your kids in 2000 in Kentucky with a large stick. You can't do it with a baseball bat, but a large stick, yeah, that's fine. That's all right. Noting the legal obligation of prosecutors to observe the independent status of the grand jury. The court found that the detective's testimony was material and affected the grand jury's decision to indict. The court also found that the Commonwealth's attorney had knowingly or recklessly elicited the incorrect testimony and that the detective voluntarily testified even though he had no personal knowledge of the facts of the case. On appeal, the Court of Appeals concurred that this deprived the grand jury of its ability to exercise its independent judgment in the case at bar. The Commonwealth elicited and Detective Clayton Stamper testified to multiple misleading statements before the Letcher County grand jury. This testimony prejudiced Mr. Stines and resulted in an indictment of murder. The case was presented to the grand jury approximately 2 months after the defendant's arrest and preliminary hearing. That's interesting. He's already had a preliminary hearing, so really the grand jury was redundant. I mean, it was extra. They did extra. And then he's not even pointing out Section 12, which is the grand jury fucking section of Kentucky's Constitution. The detective and the Attorney General's office had ample opportunity to investigate and review evidence, including witness statements, before presentation to the grand jury. Further, the AG's office conducted the investigation into Detective Ben Fields. This investigation, the resulting charges and companion civil case are central to the facts of the case sub judice. Unlike the testifying officer in Baker, Detective Stamper is the lead investigator in the case. This case is even more explicit than Baker because the court does not have to infer what facts were important to the grand jury. The grand jurors asked questions and were prevented from hearing complete answers. Had the Commonwealth presented complete and accurate testimony to the grand jury, the decision to charge, or at least the choice of appropriate charge, would likely have been different. Approximately 12 of the 25 minutes of the hearing was consumed by grand juror questions. It is evident that despite seeing a portion of the video evidence, the grand jury sought additional information to make their decision whether to indict upon what charge. Despite the grand jury's specific inquiry, known information as to allegations made during the civil case were withheld. Grand jury also sought mental health information that wasn't disclosed. The officer was permitted to testify that the defendant was in his sane mind at the time of the alleged shooting. The detective was also permitted, in contravention of the Fifth Amendment, to comment multiple times on defendant's failure to speak with law enforcement. The defendant respectfully requests an evidentiary hearing to present specific testimony and evidence relevant to the foregoing matters and asserts that such evidence will establish that the Letcher County grand jury was deprived of material information. This deprivation, the defendant contends, warrants dismissal of the indictment. Therefore, the defendant respectfully requests that this honorable court grant an evidentiary hearing to allow the presentation of testimony and evidence relevant to the issues set forth. Find that the Letcher County grand jury was deprived of material information necessary to its deliberations. Conclude that such deprivation undermined the integrity of the grand jury process and dismiss the indictment with prejudice, or grant such other and further relief as this court deems just and proper. So the grand jury indictment is pretty important because that's the Fifth Amendment, and then there's also, I feel like we're just not used to a justice system that works. Kentucky has a lot of problems with corruption. And in fact, there's a Harvard study that said that Kentucky was the most corrupt state in the Union. And so that Letcher County judge, had been before him. The fucking greasy old fat fucking pervert, goddamn Ellis Keys. He basically, sold me a box of Cracker Jacks that was horse shit. He files a fucking case, and then because he had filed the case and therefore I'm the accused, I go in and, I'm nervous as hell trying to talk to the fucking judge. They stood up on their high little pedestal and act like they're so much better. And in a way, it's like, man, I could go through this whole thing and get a jury trial and shit, but I don't really care for Letcher County. I'm just going to fucking move. I'm just going to leave. Is that all right? And then he allowed me to do that. But I want to say that was the goddamn, judge that got shot. And so that's horse shit, right? Somebody brings another person in and then automatically the fucking judge just, judges you right then and there. Well, he didn't come up very confidently. If I was a psychopathic fucking criminal fuck, just been like, hey judge, what's up, maybe I gotta learn to be more assertive, more aggressive, not like a total psychopath, but maybe if I would have said, okay, here's the deal, and then just kind of spit out, 5 minutes of just a summary of what's going on, then maybe he could have, had a better indication. But he didn't give a shit. He didn't really care for the truth of the matter. And so we made an agreement that I would be able to walk away if he would just say that I would leave Letcher County for a year. And the whole thing was fucking Alice Keys tried to rent me some land that wasn't his. He's trying to steal this this coal mining land that was abandoned, and it's adjacent to his property. And so he had rented it out to me. I paid him like $300 or whatever. But then immediately within a week we got into a fucking argument. And then it's like, man, I'm not even renting your land. I'm renting land that you're trying to adversely possess. You're trying to fucking take this fucking land over because of some sort of bullshit thing. And I'm wondering if he got away with that shit, because it was supposed to be 7 years if you could try to adversely possess land. I even bought like a Kentucky law book, a land book. But then, when it comes to the corruption of Kentucky, politics is the damnedest. There's a poem about how, the politics in Kentucky is the damnedest. But then also Daniel Boone and Abraham Lincoln. Both Abraham Lincoln and Daniel Boone, which is two of Kentucky's greatest citizens, greatest people that were, born here, made their name here, notoriety or fame, they were kicked out of Kentucky because of bullshit land deals. So it's like you can just pay some fucking lawyer some fucking money. You can also run a private practice. So you could be both a fucking judge and a lawyer and then also have a private practice, which, what the fuck? Talk about a conflict of interest. Pay the prosecutor $1,000 to go sue some, poor fucking fuck. And then after you paid the prosecutor $1,000, if you're alleged to have done something later on, well, it's like, well, shit, I just got my bread and buttered, my bread was buttered by this guy. He gave me $1,000 fucking bucks, $2,000 fucking bucks. He might give me $1,000 later on. Case dismissed. We made, Jimmy Carter sell his damn peanut farm because we didn't want the conflict of interest. It would just be nice to have somebody that just says, that they're going to uphold the Constitution. Please take notice that the foregoing motion will be heard at the convenience of this Honorable Court. Certificate of service. It was given to the Honorable Jackie Steele and R. Ramsey Dallum, Deputy Director. So I guess these are the two prosecutors that's on the case. Served via electronic service, 4th day of June, 2025. And interesting, one's from London, Kentucky, which is not close by, in Frankfurt. So they got to drive like several hours to Letcher County. Motion for our bond hearing. So now we're also going to get him a bond hearing, that's kind of interesting. But you have a right to a bail bond, a reasonable bail bond for bondable cases. So there's some cases that what's the phrase? When the presumption is great, when something is large, when it looks like the evidence of guilt is large and the presumption is great, then you're not owed a bail bond. But if there's some reasons to doubt the thing, good reasons. I mean, I like to think in math numbers. So let's say if it's like, well, 50-50. In order to prove beyond a reasonable doubt, that's 91%. Because Blackstone says we would rather let 10 guilty people go than to throw one innocent person in jail. But my understanding of the criminal justice system is that once you've been kidnapped, then the fucking courts fuck you the fuck over. The clerks turn their back on you, pretend that they don't fucking know you. They can't give you legal advice. They can't even tell you where you're supposed to sit down. They'll fucking yell at you, get your hands out of your pockets, and stand over here, go through here, make you go through a metal fucking thing, and all this other dumb shit. We can't give you no legal advice. Can you tell me processing? And they're a consistent process? No, the process is we kidnap somebody from the streets, and if we don't know you, well then we're gonna all join together and fuck you the fuck over, because fuck your life. Fuck your life. We're going to watch you get fucking raped by this court system, and that's the people that's sitting in our goddamn courthouses. So much money is spent on our courthouses. So again, a bond, you're going to let this guy that shot a judge walk away? On his face, it seems like a judge wouldn't allow it to go, but since it's a lawyer filing it, and he's got all this legalese in here, Jeremy and Carrie Bartley and James Cox. So James Cox is now on the fucking case. So now it's 3 attorneys versus 2 attorneys, right? So if you're a judge, you're looking at 3 people versus 2 people. You might just go with the numbers, right? Strength of numbers, chimpanzee kind of shit. I'm going to go with 3 people over 2, not because their arguments are, stronger and they don't have better evidence and more witnesses and better arguments, but there's 3 of them and only 2 of you. So that's some chimpanzee shit. An adversarial bond hearing, mandates of KRS Chapter 431, RCR 4.021, RCR 4.40, and Sections 16 and 17 of the Kentucky Constitution, and the 8th Amendment to the U.S. Constitution. As grounds for this motion, defendant states as follows. I think I'm going to leave it off on there. It's interesting that they're trying to get a bail bond hearing, and there is some laws that they can point to, so they've pointed out to some of the laws. At the very end, let's see, well, I like the footnotes of the grand jury when they were talking about the grand jury. I like that they're talking about the grand jury, because I'm talking a lot about the grand jury as well. Wood v. Georgia, Hoskins v. Markle, Costello v. U.S. Yep, I've come across that one, 1956. U.S. v. Dionisio, I've come across that, 1973. Internal quotation and citation omitted. So you can't just say U.S. v. Dionisio, 1973. That's like the shorthand way that I reference, major cases. You got to put all this fucking 410 U.S. 11693 S Court 764 773 35 LED 2nd edition 3067. At the end of the year, they have these major encyclopedias that are printed up, and so that's what they're saying is where this is in the big encyclopedia set of court cases and what page number. You got to make sure what page number it is too. I just don't believe there's so many douchebag lawyers that are like drunken fools. I just can't believe that anybody is actually buying the encyclopedia set of all the American federal and state court cases, and then they have like fucking year on top of year of all the damn encyclopedia court cases, and there's no consistency. There's this book making it up as they go along. I think a lot of that is going on. Making it up as they go along. You put some douchebag, he gets to be fucking judge, and maybe he was a good lawyer, maybe he's a terrible lawyer, maybe he studied a bunch, maybe he's still learning the law, maybe he just already studied the law, learned it, and then whatever he thinks he knows is good enough. You put some douchebag on a robe and put him up on high, and then they like having their asses kissed, and if somebody comes in, dressed real nice and kisses their ass, honor, your honor, judge, Mr. Judge, and then also has like a little form, here's an order, I went ahead and already printed it up to you, all you gotta do is just sign it, here's the case, blah, 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 blah. Well, hell, you might just go along with Mr. fucking Shiny Penny, right? Oh, he's, dressed like a fucking shiny penny over here. He's got a nice, what they say in the Catch Me If You Can, if you have, pinstripes. People can't take, the reason why the Yankees win the pennant is because you can't take your eyes off the pinstripes. So, let's see, Bank of NS v. U.S., 1988, quoting U.S. v. Mechanic. So, Wood v. Georgia, I feel like I've come across Wood v. Georgia, Dionisio, and Costello. So, having a similar body of law that we're looking at is important. And is there anything else here? U.S. v. Williams, Miller v. Commonwealth, 1937. Well, according to this one court case back in 1937, yeah. That's what we're going with. Stengel v. Kentucky Bar Association, 2005. Oh, well, that's 20 years ago. Even, the Baker decision is an appeals court decision, and it happened 25 years ago. Well, according to this 1935 court case, Your Honor, if you shoot a judge and you're a sheriff, you get to walk away. That's what Miller v. Commonwealth says, 1937. Oh, really?